My name is Sabine Wehnert, and I am an external PhD student at the University of Magdeburg in Germany. And I work full-time in two places, Georg Eckert Institute and Legal Horizon AG. And both institutes kind of also help me to shape my PhD. And this is now what I'm going to present. My topic is HONto, a knowledge base from textbook for legal text retrieval and recommendations. So the major task that the system should solve is to track changes in law for regulatory compliance and then recommend changes in law that could be relevant for a specific user. So in general, this is a very challenging task for practitioners since we live in a globalized world and there are usually multiple legislations that multinational firms have to consider and be up to date about. And that's kind of a challenge because there is such a high speed in which now norms are changing, especially now in our times of Corona. And the idea is basically that we have a user, for example, such a company, that kind of verbalizes what are relevant topics or norms. So somehow a kind of characterization, what are the major activities of this company. And then we want to find out if there is some overlap with what is currently discussed in the political discourse. So we do this because we want to find out if any law is changing that is maybe relevant for our user and that our user has to adapt to in order to stay compliant. And we chose parliament discussions because this is kind of the earliest point where we can estimate that things are going to change and there's enough time to adapt before the law is in force. So why isn't this easy? When we have a user context, then whatever the user verbalizes, what is relevant for him or her, this might be very different from what is discussed in a political discourse. So there's maybe a huge term mismatch. There's also ambiguity and also different abstraction levels. And this is why we came up with an idea of mediating between those two things, the user context and the political discourse, via a knowledge base. And this knowledge base should be a scalable solution to monitor political discourse, and we want to use information retrieval methods for that. So it is a sort of shallow knowledge representation, and it is a bottom-up knowledge base from literature about laws. And in this context, I should also probably characterize further what I mean when I say literature about laws, because we want to take resources that are normally used in law school. For example, when you have a certain area in law, such as tax law, then usually you probably have some books that you would like to refer to where you have also examples, situations described, and specifically also about norms, which norms are applied together in a specific situation. And this knowledge we usually don't get from the laws themselves, from the original content. We only get this knowledge either from experience, from domain experts, or hopefully from the literature that we select. So the contribution of this thesis should be to explore how knowledge from textbooks can be extracted and organized to overcome the knowledge acquisition bottleneck and to enhance retrieval methods. I will have to very briefly just sketch the state of the art because I don't have that much time. So there are already legal recommender systems for sure. For example, Open Laws EU, and also there's a recommender by Winkels and his colleagues that are quite also similar, but they differ in terms of the resources they take. So they are probably modeled on the original text of the laws and also based on ontologies that have been carefully handcrafted and that also apply reasoning and everything. But I think that we can do a bit of a different thing by using the textbook structures and therefore have more scalability in our system. And this is one of the major differences. We haven't seen any other approach that uses textbooks to make a bottom-up knowledge base and then do this for retrieval and especially for subsequent compliance checking. Speaking of which, compliance checking systems. So there are for sure many rule-based approaches with BPMN, for example, in axiomatic ontologies, and we don't even aim to be similar to that because this is not our goal. We want to be the step before it. We want to detect which laws are potentially relevant, and then such a system could be applied afterwards to find out whether compliance is still given or not on the BPMN level. So we think this is rather complementary and not kind of competing with this type of approach. And so we focus on the retrieval task that can also come before compliance checking process. Another thing is when we have the retrieval task that we have a rather high recall requirement, because if you imagine that we just miss one single important change in law, this could be a very high cost because the companies could not be compliant and then could probably get some punishment for it. And in that regard, there's also literature that focuses on how to create ground truth for high recall scenarios, because it's pretty hard to have experts annotate all examples in a big corpus and say, okay, this is now relevant or this is not relevant. And here there's, for example, a work that says we can show excerpts to the annotator instead of the whole work to make the evaluation easier and faster. And in that way, we also try to construct our knowledge base in a way that we don't have so much information overflow, that we work with keywords, ideally. And then the last thing is usability. We don't really want to overwhelm the users in exploration, because imagine you have 200 textbooks that you want to extract some concept hierarchies from. This might get a bit hard to oversee. And that's why there's also related work that kind of argues you should not let your user explore everything just freely, but kind of guide the user as well. And what you can also do is to offer explanations of your recommendations via visualization, for example, of distances using TSNE between word embeddings, and also maybe word frequencies for the overlaps. And so the idea here is also to test several techniques for UI creation and explainability to make this huge construct somehow manageable for a user. All right, so now I want to present the 3 milestones that I have defined for my PhD. The first one is to build the knowledge base. I mean, this is the core of it. The second one is to test retrieval techniques, and then also to see if we really need that knowledge base, or if we can also simply just try to match the political discourse to the user context and then be happy. And then the third thing is to evaluate the user subscription model by checking the usability, as I just described before. And then we have defined some requirements for our system that should be met. The first one is explainability. So this is an ideal requirement. We will probably not get full explainability, but it may also depend on our users' preferences. So we can have several techniques that can be selected, deep learning techniques, or rather bag of words approaches, and similar things, or also topic models. And there we can also test different retrieval algorithms and see how they perform. Second is we want to have reliability. So just in the context of the high recall scenario, if you imagine, we don't want to miss much, ideally nothing. And then stability over time is a requirement that refers to users that work with the knowledge base that have kind of already explored it a bit. If we add new books into it or remove books, then the structure of the knowledge base should not change that much. So here we could work with must-link constraints if there is something recomputed, such as with topic models. And this is also a requirement we want to meet. And then topical relevance is the last one, where we want to say that the entity context that is then used as a basis to perform the recommendations, this has to be matched with the user interest. So we don't want to just blindly recommend a norm when it has some overlap with the terms, but we also want to see if the context is right. All right, so now we have research questions for each of those milestones. And the first one is, how can we extract knowledge from textbooks to mediate between substantially different documents? This question can be answered by trying to find out the state of the art on information extraction recommendations, so kind of making experiments for the whole pipeline of this knowledge extraction on a fixed set of queries and subscriptions. Then we also, since we extract this knowledge from the textbooks, we will have to work with segmentation of the textbooks to get the extraction of table of contents parts and section titles right, to match also correctly all the citations that are in a book to its corresponding chapter, subchapter, and so on. Since there are PDFs that we would like to analyze that don't have it in their metadata. Then we want to assess the extraction error on a small study. And finally, we want to also characterize the benefit of using textbook knowledge over some other external knowledge that is probably also good. For the next milestone, we have the question, how do different degrees of explainability impact retrieval performance? So we kind of assume that there is a trade-off between explainability and performance in retrieval. And if this really holds, we want to find out. So we can have, of course, step-by-step evidence, or on the other hand, we can also show neuron activation on a given input and then see what is more useful to the user and kind of characterize what is now here the preference. Also, yes, as I already said, we want to compare to retrieval without the knowledge base to kind of justify its existence. And we have considered evaluation metrics for the retrieval tasks such as F2 score and the MAP score to emphasize ranking performance and recall. Also, we want to analyze subpopulations of interest for different legal document types. I usually speak of norms because norms have this big challenge of abstract content and then it should match to a specific situation. But we could also work with cases and see if they can also be recommended equally well. And then the final research question is about how can we present the knowledge base to a user to find and subscribe to relevant concepts effectively. So this is then again about how the information is presented and digested by the user. So here we can study the user interfaces of the knowledge base with eye trackers. For example, we can try to find out the time to find relevant concepts, also make a survey on the user experience. And also we can assess the alerting behavior because it might make a big difference if you get alerts all the time that are irrelevant, but also it's not a good thing to get not enough alerts and then miss a thing. And this is now what we have done. This was the first paper that we published about this topic, and it is about the knowledge base, basically what we call HONto, that was published in a workshop at the CIKM. And here we have defined the process that is mostly still valid nowadays, at least in the beginning. So we have a book, we apply some standard NLP preprocessing, such as tokenization, part of speech tagging, and then we annotate concepts such as the table of contents, then the sentence that contains a citation or a reference, and then finally the reference. Those concepts are annotated automatically by using regular expressions and also rules that define part of speech here. Yes, and then this is further extracted, and then you have per book one concept hierarchy that is composed of exactly those parts. The reference at the bottom, then some keywords that characterize this reference within the same sentence that it has been cited in, and then we have just the hierarchical structure of the table of contents. Looks like this. So here you can see three different concept hierarchies. So just imagine these are three different books and they all cite the article 823 of the German Civil Code that is called BGB. And you can also see that there are combinations with other articles. And then above those, you have further characteristics about the context in which this article has been cited in. For example, discrimination and crime, or also compensation by the organizer for shortcomings during a holiday. So in this way, we want to also link those hierarchies just if the context is same. So this is the kind of topical relevance that we were talking about. Only those two leftmost hierarchies should be linked and not the one that is at the right side because it's a different context. So that is here the main idea. And we have made a small graph implementation and also a fuzzy search with Elasticsearch in a small workshop paper here. That was a German venue. Finally, we also want to add into this graph the original instances or entities of the legal documents. So there should be also a note below those hierarchies that is, for example, just for the Article 823 BGB. And this will then be linked with all of those references. And for this, we need to also make entity resolution and find out, well, is there really some part pointing to this legal document or not in a reference? And then, as I said, also, we have the very contextual ones that we call here connections. So there are different ways of citing those laws in different complexity levels. So we have exact matches when we perform this entity resolution. We have also approximate ones that don't have an exact overlap. We can have range queries and also connections with multiple other articles. And then finally, we would like to retrieve laws based on a given context that the user has probably before subscribed. And for example, users interested in discrimination and crime, then this is then a subscription, and then we would retrieve 823 and 253 of the BGB. We would also know that this is somehow linked to immaterial damages because there is a connection to the other hierarchy that then further gives this context. Yes, so those requirements have been defined in the paper at the URIX in 2019. We have already talked about them. And for the second milestone now, which is about the retrieval, we have used the data sets of the Collie competition that you probably know from this conference. And especially we are interested in task 3, which is the legal information retrieval on statute law. And there we try to be competitive with an explainable method, but also try out the whole spectrum of deep learning that is not so explainable and see how we can characterize this assumed trade-off between explainability and performance. So regarding the status of this first milestone to build the knowledge base, we have already defined the concept for the knowledge base. That's the first paper that I have mentioned here. We have tested the GATE software and also Imaruta for the information extraction, and we decided to opt in for Imaruta finally. Then we have made a graph implementation in Neo4j and also made the graph searchable. And we have developed a concept for entity resolution and also made a simple UI for testing the book extraction at this company, Legal Horizon, that I'm working at, and there are ongoing updates and code reviews. For the second milestone, we want to test retrieval techniques, right? So there we have already made a very small test on an early prototype in that URIX paper that I already mentioned. And at the Collie competition in particular, we have already tested combinations of TF-IDF and word embeddings for the information retrieval task. We have tested the so-called HOT metric, which is combining topic models and word embeddings together. We have also tested various baselines such as BM25, TF-IDF, also I think BiLSTM. Yes, and this year we have tried BERT and TF-IDF combinations, and especially with sentence BERT we were pretty successful this time. Then for the third milestone, we basically already have designed the user subscription model at this workshop where we have presented the graph implementation, but there's much to do still on the usability part. So just to summarize, we have now explained what we plan and what is already existing on research towards the HONto system. The HONto system is a knowledge base to mediate between different types of documents of different abstraction levels. And this mediation shall come through concept hierarchies from textbooks which further characterize those legal document entities. What we want to do in this thesis also is to compare deep learning and more explainable retrieval methods, maybe also characterize a trade-off if it exists. And also we want to have a user explore this knowledge base and subscribe to relevant concepts or entities for obtaining recommendations. Now this is this kind of alert that I mentioned. So it should be some kind of system that also pushes notifications. Yes. So this thesis defense is planned for 2023. And with this, I conclude my talk. These are some selected sources. Now I am open for questions.
Thank you very much, Ms. Wehnert. We have the following questions sent from the audience, by the audience to you. I will send also at the chat. The first one is, how do you plan to incorporate priority in the user context? There is, which norms might be most or more relevant for the user, given that you aim for a high recall scenario? Is there any idea or on how to re-rank relevant norms by user preference?
This is a very good question. I must admit I haven't thought about making a prioritization within the user context, but I think that we could kind of circumvent this problem a little bit by letting the user also assign a priority, and also put this responsibility to the user a bit to simply mark all the concepts that are relevant for the user. And I think it will be also a service that the Legal Horizon company will offer their consulting on how to subscribe to those concepts.
Okay, we have one last question. How to apply HONto if the plan norm creates a new broad concept not described in another norm before? How does it classify as relevant or not?
Yes, I mean, this new concept is a bit hard to say, because when the user does not know that this exists and we have not any information about that it could be relevant to the user, then we maybe need to implement an extra mechanism that kind of says this is out of scope of our knowledge base. Is this still interesting for you? Yes, but I have not really put any thought on this issue. Thank you very much for pointing it out.
Okay, once more, thank you, Ms. Wehnert. And
I
now
would be
finally,
happy to have
Mr.
excuse me. I would be happy to have a follow-up question or comment on the last question. So, German jurisprudence is famous for well, hundreds of years of development of very complex, multi-level, conceptual systems. And now the question is whether this tradition has some bearing on your research. So do you make use in your annotation, for instance, in the of the classifications of norms, classifications of rights, and so on and so forth, which have been developed in German jurisprudence for dozens of years?
This is a good comment, because I think it could be built in for the prioritization as well, and the re-ranking maybe, to then say, okay, this is now a more important, I don't know, a more important law than the other one. And here we can then probably apply some of this also in a rule-based fashion. Yes.
I think so, and I also think that the making use of this knowledge type may solve many problems of new concepts, because these conceptual systems tended to be exhaustive, to build exhaustive, complete classifications of any entity or object that can be considered by legal regulation. So this may be a nice subject for future work.
Thank you very much.